Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hi, everyone, and welcome to Trial Talk, insights from legal expert Michael Joseph. Today, we're joined by John Tait, an associate attorney with the firm who handles a wide range of personal injury cases, including claims involving retail stores, supermarkets, and other commercial properties. John has significant experience litigating premises liability cases involving unsafe conditions in public spaces. I'm Sean O'Connor, and today, John and I are talking about injuries in stores and supermarkets and how the law determines who may be responsible. Very common situation. John, good to see you.
Good to see you, Sean.
So, when someone is injured, at the grocery store, they're injured in a store or supermarket. What determines whether the business itself can be held responsible?
It's really a straight negligence standard, and that's basically did the business owner act reasonably, right? Did the business owner do something that a reasonable business owner would not have done? Or conversely, did the business owner fail to do something that a reasonable business owner should have done or would have done? And that's usually a factual question for the finder of fact. It's a reasonableness standard, a reasonable business owner standard.
I get it. And in your work, what types of hazards do you see most commonly?
We get the falling products, you get the slip and falls, the wet floors, particularly in wintertime. You have products on the floor. Supermarkets are well known. People will grab stuff off the shelf, maybe eat a few grapes and walk around the store. You get display malfunctions. We've had that. We have big displays come crashing down on people. There can be many hazards in stores and supermarkets.
And so, we were talking about the standard of reasonableness. What does a store manager, the personnel, what do they actually have to do on a day-to-day basis to keep customers safe and to, sort of show, hey, we're not a dangerous place?
Sure. The law kind of, it requires store owners and supermarkets to act reasonably and make sure there are no hazards, right? It's not a guarantee that there'll be no hazards, but they have to do their best in a reasonable manner to make sure they're not. Typically, they should walk through the store on a routine basis with a specific intent, really, to look for hazards. You can't just walk through the store and wander, listen to your phone talk. You got to look for hazards on a routine basis throughout the day. Policies are always important. You have to implement policies and training of your employees to report hazards and quickly repair, remediate, or remove any of the hazards from the store. Some of the better stores have the policy, you see it, you own it, right? You see a spill, your responsibility to get it done. Don't call somebody, don't do this, go get the mop, you clean it. And that's really what a reasonable business owner would do. That's what juries have found a reasonable business owner would do: inspect their properties, ensure that it's safe to the best of their abilities, and have these policies and training in place because it's got to be inevitable that there will be hazards in stores and supermarkets, less busy ones in particular. You got to have the policies in place to deal with that.
Yeah, I see. So, especially at a trial, again, accidents are going to happen. But I'm thinking, a store in this case wants to be able to say, hey, we have it in the manual. We follow procedures to deal with this sort of thing. And, this did or did not happen. But I'm guessing that you don't want to be caught without the procedures in place. That just makes you look negligent, probably,
It does. It reflects poorly on you. When you don't have, and nowadays, juries are so attuned. They want evidence. They want video evidence. They want DNA evidence. They want evidence. The day of taking someone's word for it is over. If you say, I train him like that, then you better have it in your training materials.
Yeah. Well, I know we'll get into, the surveillance, the ubiquity of the digital realm. We'll get to that. But let's talk about timing. How does timing factor into these cases when it comes to how long a hazard was present, I guess? Oh, so again, this is speaking to your last answer around, regularly patrolling the property, the store. How does that come into play? That's, that water's been sitting there for a long time, whatever a long time.
No, timing is absolutely huge when it comes to a negligence claim against a store or supermarket because The plaintiff has the burden to show that the store or supermarket had notice of the condition
Hmm.
and an opportunity to correct it. Now, there are two ways in New York. It's called actual notice, and then you have constructive notice. Actual notice is when the store actually had notice of the condition. If the store employees saw the water come splashing down on the floor, they didn't do anything about it. They had notice. Another subset of actual notice is when the store or its employees created the condition.
Yeah.
And you get that, people mopping, store employees dropping things. If you create the condition, then you're considered to have actual notice. Now, in those situations where you can't show that the store or its employees had actual notice of this dangerous, hazardous condition, then plaintiff must show constructive notice. It's a burden on plaintiff to show that that condition existed for a sufficient amount of time that a reasonable store owner would have found the condition and taken steps to correct it. And that burden's on plaintiff. Plaintiff has to show that to a jury.
So talking about evidence, we mentioned video. I'm guessing this might come up. What types of evidence are most useful when it comes to proving a store, that they knew about, or should have known about a dangerous condition?
Yeah, well, you're correct. Surveillance video is certainly helpful to that effect.
Yeah.
It'll show not only the defect, hopefully, but how long it was there. It's particularly helpful when you see employees in the video walking by the hazardous condition before the accident and doing nothing about it. Other types of evidence are photographs. The photographs of a defect may show it was a hazardous condition for some time. It could have been run over by shopping carts, could have been stepped on by other customers. Other customers can be stepping around it. So photographs, believe it or not, could be very important evidence outside of a video. And of course, witnesses. Any witnesses who saw the condition before the accident are obviously important. They can testify to what they saw and to help establish notice to the supermarket.
Mm-hmm. Yeah, that'd be gold, right? Like I told them about it and they didn't do anything. I'm sure you've seen, right? I mean, you've seen cases where the surveillance footage from the store itself made a major difference.
Absolutely. Absolutely. A surveillance video is great because it also not just shows the condition, it really helps a jury understand what occurred. When it's captured on video, it alleviates any doubt about how the incident occurred, what caused the incident, and that the plaintiff suffered injuries. Incident reports are helpful as well.
Sure.
Because they document that an accident occurred in the store. And usually they list witnesses and sometimes even the cause of the accident and remedial measures taken after the accident. And this information is certainly helpful when you're trying to develop your case.
And the incident report, is that something that's happening at the store level? This isn't like I'm thinking police report in my head, but.
No, typically it's there are insurance requirements for supermarkets and stores. And so the incident reports are usually taken by the store employees. It could be a manager or assistant manager, and then they're actually sent off to insurance companies.
Okay.
So they can open up a claim, but they have a lot of information which insurance companies require the stores to keep, which turns out to be very helpful for plaintiff and plaintiff's counsel when they're proceeding with the case.
Yeah.
So always make sure, you fill out an incident report if you can.
Yeah, that makes sense. Earlier, I think in this conversation, talking about different causes of the accident, I'm wondering how a case might change, when the injury is caused by like a tower display falling versus melted ice, water on the floor. Does that change the nature of the case or?
Well, the negligence standard still applies. It's the same reasonable negligence standards. And often with falling merchandise or a falling display, the store will usually try and point the finger at another customer, and claim that another customer must have removed the object, manipulated display, created that hazardous condition before the item fell. Videos, of course, as we discussed, are helpful in this regard. But the store also has a responsibility to display its products in a way that a customer cannot easily make the display dangerous by simply removing a product. And you do go into some of these supermarkets. I know certainly New York City, they have those very impressive cans that go up to the ceiling. And there are cases where they come down, they're held up by cardboard boxes that are not designed to actually support the weight of these products. It's designed to contain them, and the cardboard gives way. I've seen cases, where they come quite high height, come crashing down because a cardboard box gave way. That's unreasonable. That's negligence. A reasonable supermarket would not do that. And that's same standard, but different considerations.
Yeah. I want you to know right here, I'm going to go on record. You can keep this defense, but I'm thinking we're going to call it the Jenga defense.
Absolutely.
Or not defense, but rule, the Jenga rule, right? It's like you pull something, of course it's going to fall down. What about damages, right? What types of damages can be pursued after being injured in a store?
So in New York, you get your economic damages, the medical expenses, your out-of-pocket expenses, your lost wages, and you get your non-economic damages, the pain and suffering caused by the injuries caused by the incident. And those are two categories of damages as a jury will have to come up with. You present your evidence for economic damages, pretty straightforward. Here are my lost wages. Here are my paychecks. Here are my expenses. Here's my bills. Here's, non-economic damages. It's a little harder for juries to really stick a number on. It's your pain, your suffering, how it affected your life, things you can do but not do as well because of your injuries, things you can't do because of your injuries, and how that affects you and your family. So those are the two categories of damages you're entitled to under New York law.
Okay. The way we often like to roll up these conversations is come at it from the practical side a little bit for anyone listening out there. Maybe they've been hurt, or it could happen, right? It's just good to hear, like, oh, you get hurt in a store or a supermarket, right? What steps should they take to protect their rights?
Sure. A couple things you want to do, and again, this is if you're injured and you're going away by an ambulance, don't worry about these things. If you're a bit, or if you can, or if you have a friend or someone you're with who can, make sure you can make a report with the store if that's an option. If they're going to willing to accept a report, you make a report. You take out your phone, you take photographs of the hazardous condition. When you're deposed or you're testifying 2 years later, sometimes it's difficult to explain to a jury what the hazardous condition looked like, how large it was. You take a photograph of it, you have it. You want to get the names and addresses of any witnesses, and of course, call a personal injury attorney, one with experience, and they'll walk you the rest of the way through.
Oh, that's good. That's good. I was thinking about the as a consumer, I got I'm going through a store, I slip, I fall, I twist my ankle, and I'm we talked earlier about the ubiquity of cameras these days. How do I access the footage, or is that's something that you would do right away if I called you?
So no, there's no real trick to it. It's what we do is we draft what's called a preservation letter, and I send that out. As soon as the retainer is signed, the first thing out the door is a preservation letter, and that letter advises the landowner, store, supermarket, whatever it might be, that there is a claim, that they have an obligation under New York law to preserve evidence. And of course, if they do not preserve that evidence and it's later destroyed or gotten rid of, then you can get a spoliation of evidence instruction to the jury. The jury can be told, they have the right, not the obligation, but they may, if they want, to assume that destroyed video would have been favorable to the plaintiff.
Yeah.
And so we send out the preservation letter. We also, tell them, hey, listen, put your insurance carrier on notice, because we don't want them to lose insurance coverage because they decided not to tell their insurance company. So we tell them the claim, we give them the preservation letter, preserve videos, documents, and then, insurance notice. So anyone can do that. You don't need to be a lawyer to do that. It's just smart to let them know about the claim. And one of the benefits of the incident report is they then have notice that they must preserve the videos.
Ah,
And of course,
it.
usually they get sent straight to the insurance company, so the insurance company now has notice as well. So fill out an incident report, have a friend fill it out if you're going to the hospital. If you got to go back the next day or 2 days later, go back the next day or 2 days later and call an attorney.
Yeah, no, that's good. Yeah, but ideally that incident report triggers some legal things. So
It
that's
does.
that's good to know. Good to know. Well, John, we're out of time, but as usual, great to talk to you.
It was great talking to you.
I look forward to a future conversation.
All right.
That's it for today's episode of Trial Talk, insights from legal expert Michael Joseph and today's guest, John Tait. If you or someone you know has been injured in a store or commercial property, you can visit their website, newyorktriallawyers.org, to learn more about your legal options and connect with their team. My name's Sean O'Connor. Thank you for listening, and do us a favor, leave a thumbs up, share a link, subscribe to the podcast. That's always really helpful for everyone. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.